Welcome, everybody, and thank you very much indeed for joining us, whether it's your morning, your lunchtime, or for some your evening. We are delighted that you've been able to join us this morning, and apologies for the slight delay for technical reasons. This is the second of a series of banking and financial services webinar presented by 39 Essex Chambers. This episode deals with the DIFC Courts, and we are honoured and pleased to have with us our colleague from Chambers, Chief Justice Wayne Martin. We are pleased to say that there are over 200 people attending this event, and we hope that you will find it of interest. This will be a round screen panel discussion focusing on a number of current and future themes or issues referencing DIFC case law where we consider it appropriate. We will be speaking without slides, and we hope you will find it informative and useful. We have the unique advantage of being able to call on Chief Justice Wayne Martin as a member of 39 Essex Chambers to join us on this panel. In the usual way, there is a Q&A function, and I'll endeavour to monitor that inbox during the webinar. It is unlikely that we will be able to reach all of the questions sent, and if the questioner chooses to leave his or her email address, we will respond briefly by email in due course. We intend to keep this webinar to time and to finish at 9 o'clock UK time to allow you to start your day or resume your working day. A few panel introductions, if I may. First, Chief Justice of the DIFC Courts, the Honourable Wayne Martin AC KC. Before his recent appointment to that position and since 2019, Chief Justice Martin served as a judge in the DIFC Courts, both at first instance and in the Court of Appeal. In 2022, he was appointed judge in charge of the Technology and Construction Division. Before his time at the DIFC, he was, amongst other things, the Chief Justice of Western Australia from 26 to 2018. My name is Jonathan Bellamy. I'm chairing this webinar. I'm a commercial barrister and arbitrator at 39 Essex Chambers based in London, practicing in both capacities, both in London and internationally in the Middle East and in Asia from our Chambers offices in Singapore. Banking and fraud disputes form an important part of my practice, and I'm a licensed practitioner of the DIFC Courts. Also on the panel today, we have Karishma Vora. Karishma is a commercial practitioner qualified not only in England, Wales, but also in India, and also a practitioner and an active practitioner at the DIFC Courts in Dubai. Recently, she appeared successfully in the Emirates NBD versus KBBOD case in the DIFC Courts. James Scherf is a commercial barrister based in London, a former solicitor at a leading global firm. His practice has a significant international element, including banking and financial services. Finally, Alex Burrell has extensive experience in DIFC disputes, having worked on secondment in the arbitration and DIFC team at a leading Dubai law firm for 2 years, and has remained a DIFC licensed practitioner since returning to the UK, frequently appearing in the DIFC Courts. As I said, we approached this matter as a roundtable discussion with certain themes which we picked out from recent case law, in particular case law over the last 18 months or so. I'm going to start by focusing on the theme of the DIFC Courts as a bold and developing jurisdiction. First, it's, in our view, important to recognise that the DIFC Court is a developing jurisdiction. That presents both a challenge and a lot of advantages, a freedom, if you will, to develop the law and procedure in a way unconstrained by certain historic and in particular common law principles. As you will know, the DIFC Court operate on a common law basis. But that common law, unlike, for example, the approach taken in ADGM, is not necessarily linked to the English commercial common law. It is heavily influenced, the decisions show, by common law jurisdictions, including England and Wales, Australia, and other established commercial jurisdictions. But as I say, unlike ADGM, it does not self-avowedly limit itself to applying English commercial law. The DIFC courts are located in a very important international banking and finance jurisdiction, an offshore jurisdiction onshore, physically within the UAE. That makes the function and success of the commercial and banking legal jurisdiction in DIFC courts of particular importance. As we all know, Dubai is well connected internationally in the international financial markets and in international banking circles. The decisions which I will refer to, and more generally the theme underlying this as we see it, is that the DIFC courts have embraced the concept of internationalism and comity with other leading offshore and onshore jurisdictions. It has not felt itself limited to creating its own case law for only its own purposes. One particular example of this, which I'll return to towards the end of my few words, is the recent case of Gate Mena, Huobi, also known as, on cryptocurrency. But I want also to focus on general banking and financial principles as the bedrock, if you will, of financial transactions. One of the advantages of the DIFC judgments for the practitioner is their brevity. It is a pleasure as a commercial practitioner, used on many occasions to dealing with very lengthy decisions which recite historic principles, to read judgments which are not constrained in that manner. On my reading of many of these decisions, the dispositive concluding sections are clearly written. They are taken as matters of principle and are very useful for practitioners. I'm going to focus on just two particular points to illustrate those themes. The first is a point about Norwich Pharmacal. As you will know, in this jurisdiction in England and Wales, there is a highly developed and relevant jurisdiction for Norwich Pharmacal and indeed also Bankers Trust applications. The courts in this country have drawn traditionally a distinction between obtaining information on the one hand and evidence on the other, and to that end have limited the scope of Norwich Pharmacal proceedings, which is of course originally a common law remedy and jurisdiction, to obtaining information, drawing a distinction, as I say, against evidence. In relation to proceedings in other jurisdictions, that distinction has created a limiting factor for the English courts. What it's meant is that the decisions which we have to date state that the Norwich Pharmacal remedy is not available to obtain information in relation to foreign proceedings. The cases cite the treaties and letters of request route that are available for foreign proceedings. Now, in today's international global banking markets, in particular fraud cases and asset tracing matters, there are real practical problems with the letters of request route. First, it's slow, and secondly, it inevitably tips off various individuals who may wish to move assets out of reach of remedies which can be used if information is obtained privately and without notice to those individuals. So the case which I'm going to focus on briefly is the SCAT decision, SKAT versus FFA, in the DIFC Courts. Now, this is a pleasingly brief 13-page judgment. It is clearly written. It sets out the historical basis for Norwich Pharmacal in the English jurisdiction, but also, and importantly, refers to the approach of other reputable offshore jurisdictions and the way in which they've dealt with this question. The DIFC courts have taken a different approach to the English courts. And what they have decided is that they have power to issue Norwich Pharmacal remedies where in support of foreign proceedings. In that particular instance, it was a well-known piece of extensive litigation involving fraud on the Danish governmental body, the SKAT, taking place in London. And the result of that approach by the DIFC court has been to align it with other jurisdictions such as the Cayman Islands in a case called SR Global Fund and ArcelorMittal, and other reputable offshore jurisdictions, including Jersey, Guernsey, the Isle of Man, and Gibraltar. And we find it interesting that the court in that case, you'll find it for those who are particularly interested in paragraph 14, talk about comity, the contravention of international agreements, and the need for international cooperation. They also make the point, or the court also makes the point, that unlike England, it is not constrained or does not start from the same position of the common law, but operates from the statutes incorporating and establishing the DIFC courts. So that is an example for us of an area, an important practical area of banking and finance services law, where the DIFC courts have taken their own path. And we consider that it is an effective and positive development in its own jurisdiction. I'm going to turn secondly and finally on this particular point to the question of cryptocurrency and the Mena Huobi decision. I'm going to address this quite shortly because you may very well be familiar that it's received an awful lot of publicity since its publication earlier this year. And really more importantly, at the same time and in parallel, the DIFC, of course, has passed the Digital Assets Law number 2 of 2024. In short terms, the court has found in that case that cryptocurrency is capable of constituting property in what's described as a third form, adopting on that occasion an analysis set out by the English Law Commission. But in practical terms, what it's done is permit or create an analysis which permits parties to hold, control, own, and protect cryptocurrency and other digital assets. Again, one of the important points made about it during the course of this decision is the freedom that the DIFC court has to make this decision, and the analysis starting with the law of obligations, which constitutes a statutory source of its analysis in this case. I'm going to turn finally, before inviting any other comments, firstly from the Chief Justice Martin and any others on this point, to the digital assets law. Going forward, that is something which any practitioner involved in cryptocurrency and digital assets disputes should be well aware of. It's in force. It contains a definition section, which I certainly won't read out, but is of interest to you. It describes under the title characterization, it's Article 9, as digital assets as being, quotes, intangible property and neither a thing in possession nor a thing in action. And that is the juridical basis for claims, whether it's in bailment or interference going forward. It sets out the test for control of a digital asset and also general rules as to title. And again, I'm going to wind up my part on this by saying this is an example of the DIFC jurisdiction leading on a particular current matter of banking and finance. So, Chief Justice Martin, I was wondering whether you wanted to say anything on this particular area at this point.
Yeah, let me unmute myself first. I will offer a few comments and I hope they might be helpful. Firstly, in terms of internationalism, in a paper recently delivered by V.K. Raja in Singapore, he expressed the view that the DIFC court was in fact the first truly international court, in the sense that the DIFC has its own special rules which have been fashioned with a view to international trade and international customers and international users. And it's also, of course, long been our jurisdiction that any two parties anywhere in the world can opt into our jurisdiction. There is nothing else required in order to establish jurisdiction. And so consistently with that, we've tried to remain at the cutting edge, if you like, of international developments, which include international currencies like cryptocurrency. And so, as you say, we've got the law of DIFC law is now, I think, cutting edge in that area. And now one judge in particular, Justice Michael Black, has made it his business to be well on top of all the issues that arise in that complicated area, which I have to confess I don't fully understand. But there are other areas which are sort of, if you like, transcend national boundaries, where we're trying to take a lead as well. For example, we're very interested in the law of space. And so we've had the judges have all been attending recent seminars about the law relating to issues that occur in space, of course, well beyond any national boundaries. So again, those sort of things are consistent with our international approach, as is other notions of international comity, which you mentioned in the context of the Norwich Pharmacal type of orders. The same sort of issue arises in another area where we have we had a thriving practice in worldwide freezing orders. And there are issues there about the extent of our jurisdiction. And a couple of judges of the court, including Sir Jeremy Cook and I, took the view that because we had jurisdiction to enforce the judgments of other courts after recognition, we also have jurisdiction to preserve assets in aid of that jurisdiction to enforce. And so that, for example, in the case that I dealt with, there were proceedings in Hong Kong in relation to allegedly misappropriated funds, which happened to be found in a bank in Dubai. And an application was made to our court for a freezing order in relation to those funds, and I granted it on the basis of that we had jurisdiction, if you like, anticipatory jurisdiction in aid of our enforcement jurisdiction, relying upon Privy Council authority, the name of which I can't recall, which said that that is the font of that type of jurisdiction. A Court of Appeal in another case, Sandra Holdings, took a different view and said that the court's jurisdiction is exclusively statutory. And so unless there was an express provision in the statutes of the if you like, the judicial authority law, which is the primary font of our jurisdiction, there was no jurisdiction. Now that caused a bit of consternation, because we I certainly took the view that international comity required us to be able to assist other courts, in this case the Court of Hong Kong, in order to preserve assets to be available to enforce its judgment if and when the time arose. Anyway, to cut a long story short, in the case I was in, it's gone back to the Court of Appeal, and they have reheard the issue and they've reopened it in order to ascertain whether, in fact, Sandra Holdings was rightly decided. But in any event, there is legislation in train which will, in effect, reverse that decision in Sandra Holdings. So it's a question of which comes first, whether the Court of Appeal reverses it or the legislation reverses it. So again, that's, I think, consistent with our aspiration to be fully international in things that we do, and to foster international comity with other like courts. I've said too much, so I'll stop now.
Not at all. Thank you very much indeed. I'm going to move on to our second theme, that of legal orthodoxy, often but not always. And on this one, James is going to lead.
Thank you very much, Jonathan. I think that for practitioners, the DIFC can be relied upon as a jurisdiction that promotes legal orthodoxy, and that does give litigants the comfort of knowing they can, for the most part, safely rely upon established principles in prosecuting their case. I just want to refer to the decision of Mena Gates, which Jonathan referred to, and to which the Chief Justice also referred, on this question of stare decisis and how that feeds into orthodoxy. And there's an important distinction, I think, here between what is going on in the DIFC and what is happening in the ADGM. As many on this webinar will know, the ADGM in 2024, comprising a very powerful bench, Lord Hope, Justice Hayne, and Justice Blanchard, had to deal with a situation where there were conflicting decisions of the English Court of Appeal on a question that's very central in banking cases often, as to whether it's a defense to an action for conspiracy to injure by unlawful means that the defendant acts in the belief that she has acted lawfully. And what happened there was a 2008 decision of the Court of Appeal, the English Court of Appeal, which said that the defendant could invoke her lawful belief, but a 2021 decision where a majority of the court said that unlawfulness or knowledge of the unlawfulness was not a requirement. And at first instance, the judge had followed the 2008 decision, but the ADGM Court of Appeal reversed on this point, saying the judge should have followed the 2021 English decision by an orthodox application of the doctrine of stare decisis. And that can be contrasted with the Mena decision by Justice Black, the DIFC Court of Appeal decision. In that case, Justice Black referred to the ADGM Court of Appeal as our sister court, that is the DIFC's sister court. And as the Chief Justice has said, Justice Black in that decision said that the DIFC jurisdiction is statutory, and therefore it is legitimate to look to other jurisdictions, including, in principle, non-common law jurisdictions, as part of the incremental development of DIFC law. And Justice Black said there that the DIFC courts were not obliged to follow another legal system, but rather could call upon any relevant common law principles and international jurisprudence from any jurisdiction to assist in the interpretation of DIFC legislation. That's a very different proposition from that, for example, which pertains in the ADGM. And it reflects a difference of approach because the ADGM jurisdiction is also statutory. So that's not really the proper point of departure. Rather, there is a willingness on the part of the DIFC courts not to be restricted by the position in England. And if the AC network case had come, that's the ADGM decision, had come before the DIFC courts, I'm bound to say that a DIFC judge would have been free to follow either the 2008 or 21 English Court of Appeal decision. And there's an instance of how orthodoxy plays out in the DIFC Court of Appeals decision in SBM and Renish, which dealt with the principles applicable to claims in deceit or for fraudulent misrepresentation. And there, the court was discussing the law that pertains to implied representations, and it said that the test was the same as what you would apply for an express representation. Namely, the court will undertake an objective assessment of what a reasonable person would have inferred from the representor's words and conduct, considering the surrounding circumstances. That could include contractual and other documentation passing between the parties. and the court there upheld the trial judge's assessment that the presentation of a document for payment amounts to an implied representation that a payment request was genuine and bona fide. This seems like a very orthodox application of principle, but it all depends on the context. And this can be contrasted with a very recent decision from the Chancery Division in England, Allianz and Barclays. There, Mr. Justice Leach considered the exact same authorities that the DIFC Court of Appeal considered in Renish on implied representations. Mr. Justice Leach was dealing with a claim for securities fraud, a claim under the Section 90A of the Financial Services and Markets Act in respect of misleading material in a publication made to the market. And there, Mr. Justice Leach said that the representee must read and consider the published information that led to the misrepresentation. Simply pointing to the misrepresentation in the form of a document was not enough. And the important point is that Mr. Justice Leach said quite expressly that he was applying orthodox principles too. So what is orthodox can be a very fact-sensitive question.
James, thank you. It can also be a very individual concept, can't it? One person's orthodoxy is in others not. Chief Justice, I wonder whether we might just entice you to make some comments on this.
Absolutely. Look, as you both observed, one of the key differences between DIFC Court and ADGM is that ADGM has a statutory provision saying that in default of ADGM law, the English common law applies. We have no such provision. And so we are freer than ADGM Court to look at other sources of law, as Justice Black observed in Gate Mena. Of course, ADGM crow and say that that is an important point of distinction in their favour. And they said that in quite very, if you like, promotionary terms for their court in a decision, AC Network and Polymath in November of 2023, and actually drew a contrast between their court and our court and said, if you come to the ADGM court, you have certainty, you have greater certainty, which is certainly true. But certainty comes at a price, and the price is that you have to take developments in English common law, whether you think they're desirable or not. And so there are some instances in which I think, and the problem with the ADGM is it assumes that the English common law can be appropriately translated entirely into a Middle Eastern setting. I'm just not sure that that's right. And there are some other areas of recent development in English common law, which I think a lot of people scratch their heads about. The Braganza duty, the implied duty of good faith is, I think, an area of uncertainty. And recently I looked at the area of illegality, the defence of illegality, which it seems to me in the current state of English law is a bit of a mess. Following Patel and Mirza, there's a question mark about the reliability of preceding authority. Henderson in the recent decision hasn't actually helped that a lot. So we, as I say, DIFC is reserving the right to look around for sources of law. There is a limit to how much we can plug gaps in DIFC law by reference to the common law, and so there have been issues about the extent to which we can import torts into the substantive law of the DIFC if they're not actually in the law of obligation, which is the DIFC tort law. But again, there's a legislative initiative underway which will give us a legislative power to fill gaps by reference to common law principles from any jurisdiction which we think are apt for application in DIFC. And through that way, we hope to be able to build what will effectively be the common law of the DIFC. In the same way as in Australia, we now talk about the common law of Australia rather than the common law of England, because we have diverged from the common law of England and Wales in a number of respects. So that's the road we want to go down. We think it provides flexibility and provides us with the opportunity to shape the law in a way that suits the DIFC, which, as I say, is primarily international and primarily has international customers. So,
thank you very much indeed. Karishma, would you like to contribute anything on this particular topic? We're on orthodoxy. We're going to move to legal certainty next. Karishma.
Thank you. On orthodoxy, I wonder if the Sandra Holdings decision that Justice Martin referred to a little earlier could be sort of termed as an orthodox decision, but it's also a leading decision because the English law follows the decision of Sandra Holdings in a 2024 decision called MEX. So while I think within the DIFC and in Dubai, they have been critical of the decision, of the DIFC decision, in the sense that they say the Sandra Holdings clips the wings of the DIFC to grant a freezing injunction. That is, in fact, the ratio that has been followed in MEX in England. So in MEX, there were proceedings on foot in Hong Kong, and it was held that it was inexpedient for the English courts to grant a freezing injunction in support of foreign proceedings, which is very similar to the facts in Sandra Holdings, without a real connecting link to England. And the real connecting link really was, again, the same as in Sandra Holdings, residence within the jurisdiction of the party that one is seeking a freezing injunction against, presence of assets within the jurisdiction, or an in-person jurisdiction. So it remains to be seen whether the Sandra Holdings decision of the DIFC is really an orthodox decision or a leading decision. And I guess the Court of Appeal, when it hears the appeal in the Carmen case, which will consider the Sandra Holdings case, will have an opportunity to consider the Lex case from London.
I think that appeal's actually been heard and is reserved. I might be wrong there, but I think it's been reserved. I may be wrong, but I think that's right.
Well,
hopefully they've had a chance to consider MEX. But over to you, Jonathan.
No, not at all. Thank you, Karishma. Alex, I think you had something to develop out of this as well.
Yeah, so a related point, and it's actually something that Chief Justice Wayne Martin touched upon, is legal certainty. So legal orthodoxy and certainty are related concepts, or they're slightly different. And it's interesting, there's a couple of decisions from the DIFC courts in terms of how they would apply certain concepts in relation to implied terms of good faith and Bruganta type duties, which suggests that they're moving in a certain way in relation to certainty. It seems that the DIFC courts are quite keen to ensure that there is sufficient certainty for parties in relation to banking, finance and other cases, holding parties in effect to their contractual bargains rather than allowing potential legal doctrines to interfere with contractual terms. The DIFC is an interesting jurisdiction in that, as has already been discussed, it does differ from the English common law, but in material ways. For example, in the DIFC law of contracts and Article 57, there are stated to be implied obligations arising out of good faith and fair dealing. So there's statutory backing for implied terms in relation to good faith. There had been some discussion about whether this type of provision would be perhaps closer to a civil law concept of good faith, which you see in the domestic UAE disputes, which some may have experience with in arbitration or otherwise, and is often deployed to try and override or get around express terms that a party doesn't like in a dispute for whatever reason. But even in a sort of more diluted way than what you see in the UAE law, it's common for parties to try and use this implied term in combination with some other common law type principle or other doctrine to affect the application or the usual application of express terms. And we see that some of these arguments, in some cases at least, have been rejected by the DIFC courts. So in the case of Kirtanlal and State Bank of India, so SBI and others, and that was a decision of Justice Jeremy Cook in October last year, Kirtanlal, the claimant, had its facilities suspended and then terminated, and they were trying to challenge those decisions. And they argued that SBI variously owed a duty to act in good faith imposed by Article 57 of the contract law, alternatively an implied term of good faith and fair dealing, again arising out of Article 57. And they also relied on Bruganta type duties, and they said effectively that the contractual rights to suspend or terminate should not be exercised arbitrarily, capriciously, irrationally, or when without reasonable and proper cause. That was quite pithily rejected by Justice Cook, saying he held that none of these points carry any weight at all in the face of sophisticated banking documentation, which spelled out the rights of SBI in the manner of the circumstances in that case. It held that SBI had rightly terminated the contract, a terminating party is entitled to act in its own best interests as it sees them, and its motive for exercising them is irrelevant. And a party which is given the right to terminate does not have to exercise that right reasonably, whether objectively or in a Wednesbury sense, nor is there any duty to take into account certain factors or not take into account other factors. And any obligation of good faith, which is implied into the contract, can't impact upon that express right. And Kirtanlal also references a Court of Appeal case, the DIFC Court of Appeal case that I was involved in, Panther Real Estate and Modern Executive Systems, in which I was, for the defendant, seeking to rely upon the implied term of good faith in that case. And unfortunately, I was on the wrong end of the judgment. But it was perhaps not surprising in that the DIFC courts are clearly favouring certainty of the application of express terms rather than allowing potential concepts to undermine the certainty of contractual application. And so in that regard, at least in relation to an analysis on those two cases, and that there's an indication towards a more classic common law or orthodox approach. And there are obviously some benefits to that in banking and finance, in that parties' expectations as to their contractual rights is given more certainty. So yeah, it's also perhaps more similar to certain approaches in the UK where there is less of a or no statutory backing for certain implied terms.
Alex, thank you. Naturally, I'm going to invite Chief Justice to express his thoughts on this particular point as well. But just going back to a couple of points you made there, and you mentioned that it's an interesting jurisdiction, as we know it is. I mean, you have, don't you, in the DIFC law of contract, Article 57C, and providing obligations of good faith and fair dealing. And I wondered, Alex, what you thought about that and how that impacts the court's approach to legal certainty.
Yeah, I mean, from the time that I've tried to use that as an argument, and the DIFC Court of Appeal didn't go very well, unfortunately. I tried to use it in relation to a construction principle, but it was effectively roundly rejected. But in relation to banking and finance, again, the same approach was tried in the Kirtanlal case, to try and affect the manner in which a termination clause can be exercised. And that argument was rejected. So there must still be some scope to rely upon those type of implied terms, but to the extent that you're trying to rely upon them to get around or avoid the consequences of other express terms, it seems that the DIFC Court's approach is not sympathetic to those types of arguments.
It would be fair to say that there's always a tension between certainty and justice in any commercial dispute, but probably particularly in banking finance, certainty is of importance. And Chief Justice, I wonder what you might want to add to this particular.
I agree entirely with Alex's comments. The trend, I think, through the DIFC cases is what used to be called black letter law. In other words, if the agreement sets out the rights and obligations of the parties, then that's what they are. And of course, we do a lot of banking cases in the DIFC, and people, when they borrow through banks in the DIFC, they tend to borrow hundreds of millions, not just small amounts. And so the documentation that comes with those borrowings of that magnitude is very thorough and very comprehensive, and very often doesn't actually adopt DIFC law. Very often adopts, for example, the law of England, Wales, or some other jurisdiction, sometimes even Switzerland if it's a Swiss bank involved. So very often we're applying international law rather than DIFC law. But even under DIFC law, I agree with Alex, if the agreement is specific and defines the parties' rights, then the starting point, I think, for the DIFC court is that that's what will determine what the content of those rights and obligations. And again, so it's in other words, it's fostering certainty in that respect.
Yeah, thank you very much. Well, some of us have tried to make a career out of telling clients to read the contract. James, briefly on this, if you wish to add anything, we're going to turn to Karishma on some other matters in just a second, but is there anything you'd like to add?
Yeah, just one kind of footnote. I mean, this is related to the question of whether supervening legal duties, for example, obligations in tort, can be applied over and above the obligations to which the parties have signed up in their contractual documents. And on this, there's a point of potential departure between English common law and what is going on, or what has gone on in the DIFC. Many on this webinar will remember a Court of First Instance decision, DIFC, and from 2021 called Aegis Resources and Union Bank of India. And in that case, the DIFC court upheld the application of the so-called quince care duty. That's the bank's tortious obligation to use reasonable skill and care when executing a customer's payment instruction to check that the payment instruction has come from a legitimate source. And in that case, the DIFC actually extended the application of the quince care duty to a situation where the bank had received a payment instruction from a third party purporting to be an authorized signatory on the account. Most of the case law concerned a situation where the person giving the instruction was an authorized signatory on the account, but they had gone rogue for some reason. So that was actually an extension of the existing quince care duty. And there's a real question mark, I think, over what direction the DIFC courts will take when this issue inevitably crops up again, given the decision we had last year out of the UK Supreme Court, Philip and Barclays Bank, which effectively abrogated the quince care duty by saying there was no special duty over and above the bank's ordinary duty of skill and care that it owes to its customer when processing payment instructions.
James, thank you. Because there may be a future case, I'm not going to invite the Chief Justice to comment on that just at the moment. But I agree, Philip's fascinating case and probably indicative of the approach of some of the senior Supreme Court judges from commercial backgrounds at the moment in the court. Thank you very much indeed. Now, I'm going to move to our final topic before inviting some comments on where the future may lie for the DIFC in terms of legal development. Karishma, we've kicked back the chair and talked about some grand and interesting principles, but we're going to invite you to do some nuts and bolts, aren't we, on summary judgment and personal guarantees, if you like, the coalface of banking disputes.
Yes, thank you, Jonathan. It segues very nicely into certainty, because while certainty, as Alex and Justice Martin have just discussed, is important, and the DIFC courts will uphold what is the letter of the contract, it is a unique jurisdiction because it also has this interplay of legislation. And in one of, also a Union Bank decision, in one of the Union Bank decisions, there were several facility agreements, and there was an all monies guarantee. But while an all monies guarantee is can be upheld under English law, there is legislation in the UAE preventing it from being upheld. So in this particular case, the guarantee was really wide, all-encompassing. It encompassed it. It said that the guarantors would guarantee future debt, so debt that and monies that had not been lent at the time that the guarantees had been signed, which is usual. But what was unusual is that it went further, and it said that it would also guarantee debt under any other agreement. So not just the facility agreement, but any other agreement that was part of the same transaction. And it was held by the DIFC court that this was a void guarantee, and that it would not uphold this contract between the parties, because an all monies guarantee under UAE law, so under UAE legislation, is disallowed. And another small point in that is that there was an annual review clause for the facility agreement, which was inserted following a number of facility agreements between the parties. So this annual review clause basically said that following the expiry of 1 year, the facility agreement would need to be renewed by both parties. No such review took place, and therefore the court held that it had expired. Because it had expired, the DIFC court also held that the guarantees that were linked with the expired facility agreement could no longer be enforced. So some very interesting outcomes, certainty, but also sort of a move to the future. And interplaying with the internationalism of the DIFC courts, I think another theme that many of us are facing is when bringing witnesses to our trials, a lot of our trials now have become hybrid post-COVID. So while the legal teams might be in the courtroom, witnesses often give evidence from abroad. And it has become a recurrent feature of many of my trials that judges seek permission, or rather ask the parties to seek permission from the jurisdiction where the witnesses are giving evidence. And once again, in this case, since that application was brought at the very last minute by one of the parties, in a bold move, the DIFC court on the first day of trial said it would allow the witnesses to give evidence from abroad and would allow until the end of the week for them to produce evidence that they were allowed under their particular jurisdiction to give evidence via video link. Again, quite a practical move rather than just adjourning the trial. In terms of daily working, the uniqueness of the DIFC also is that the sort of jurisdiction tussle is not just with international courts, but also within the UAE. So there is the DIFC, which is a kind of oasis, and then there are the wider UAE local courts, which are the local Sharia courts. And there have been instances in one of my cases where it was a very hotly contested freezing injunction, and just before judgment was to be pronounced in the KBBO case, one of the parties went off. So this was a freezing injunction hearing at the DIFC. In the middle of that hearing, the party goes to the local courts, and the moment that happens, both courts have to stall proceedings. No further judgments can be pronounced, even if they have been drafted. And the matter was previously sent to what was known as the JJC to determine which court would have jurisdiction. This has now been replaced by the new judicial authorities law. And this is useful because it brings into play not just the tussle between the DIFC and the local Dubai court, but it includes any decisions, for example, from the ruler of Dubai and other courts such as the rent control courts and so on. This is quite a step forward in order to sort of bring more certainty into which court has jurisdiction, whether it should be the DIFC or the local court. And the authority continues to be comprised of 6 individuals. So it would be 3 judges from the local courts and 3 from the DIFC. So that, I think, is a very good step forward. And speaking very quickly on anti-suit injunctions, this goes back to our original theme of boldness and really the DIFC leading the way. It has made, in my view, quite fair decisions on anti-suit injunctions. And in instances where I have also explained where there's this jurisdiction tussle between the DIFC and the local court, the DIFC has, again in the KBBO case, not hesitated from pronouncing an anti-suit injunction, preventing the defendant's guarantors in that instance from going to the local court. That really is a very bold decision. Of course, this has been nuanced and it has been developed, and more recently in the Lear anti-suit injunction case, Justice Black has said, well, in the event of arbitrations in different jurisdictions, while the DIFC would grant an anti-suit injunction, there needed to really be proof that DIFC was the seat. And without such proof that DIFC was the seat of arbitration, it would not be amenable to granting an anti-suit injunction.
Karishma, thank you very much. I'm going to just park, if I may, the judicial conflicts authority point that you raised there, because I'd really like to see what anyone, particularly the Chief Justice, would like to say at the end in terms of the future. It's right, isn't it, that in the Union Bank decision, that concerned, it was a UAE law case concerning Article 1061, which, as many of our audience will know, refers specifically to it being a condition of the validity of suretyship, that it refers to what's translated as a known debt. And I think it would be right, wouldn't it, that decision should not be interpreted as prohibiting DIFC law from enforcing all monies guarantees where the choice of law is another jurisdiction, including DIFC law.
Yes, of course, that would be right. So
yeah,
yes. Sorry,
That's what I think it's important that decision is not misunderstood for that reason. James, just before we come to pushing back the chair once again in conclusion on perhaps where matters may go in future, do you want, I know you've had some involvement with the English side of NMC, haven't you? And have some thoughts on guarantees. Is there anything you'd like to add on this?
No, I mean, yes, so I do. I'm part of the council team acting for the administrators of NMC Health PLC, which is the formerly LSE listed company that sat above the NMC group against the former auditors of that company, Ernst & Young, in their current proceedings before the commercial court in London. There's been a whole raft of litigation related to the fallout from the collapse of NMC in both the DIFC and the ADGM, and also in the onshore courts of the UAE. There's an interesting point about guarantees and also kind of about the approach to summary judgment generally, which came up in quite a recent DIFC decision of Justice Lemire under Part 24 of the DIFC rules concerning immediate judgment, summary judgment. And it's quite interesting. The question was there about whether there could be summary judgment on the question of whether the former principal of NMC Health, the healthcare group, Mr. Shetty, had signed a guarantee. And Justice Lemire reminded us in his recent judgment that although immediate judgment, summary judgment, is not supposed to involve a mini trial of the facts, the court may and should dispose of issues that depend on factual assertions that are of no substance. And so, as I said, the question there was whether Mr. Shetty had signed a guarantee of NMC subsidiaries' debt with the claimant bank, which was Punjab National Bank. And there was no evidence of substance that Mr. Shetty had not signed it. All there was his witness statement saying he did not recall signing it. He had put forward a handwriting expert who suggested that it was questionable whether his signature was on the document. But even on an application for immediate judgment, Justice Lemire said, or was able to say, that that evidence was not good enough or was not strong enough such that it required the case to proceed to a trial. And Justice Lemire thought that the report was misconceived, and he was able to say so on an immediate judgment application, and so that application was granted in the bank's favor.
Thank you very much. Alex, just in the several minutes which remain for us, taking very much the opportunity with the Chief Justice here to say what he would like about the future. You've been picking up some information that's been circulating in Dubai about extensions of jurisdiction and consultation papers, I know, haven't you?
Sorry, I'm mute. So I think towards the end of last year, there was a survey put out saying, I think titled Beyond Common Law Beyond the DIFC, Evaluating Proposed Legal Frameworks for Free Zone Jurisdictions. And I think there were a couple of different options, one a sort of hybrid option, another option for effectively extending the DIFC's jurisdiction beyond the actual DIFC in Dubai to other potential free zones. There's not been anything official since then, but yeah, it's expected that a decision on that may be coming soon, and so we may possibly be seeing the expansion of the DIFC to further areas of Dubai, which obviously would be a very significant development of the DIFC courts. Sorry, expansion of the DIFC law. Sorry, not the DIFC. To these other zones, which would obviously be a quite big deal for the work in the DIFC courts and the type of contractual disputes that we might start seeing there.
Good.
You're just on mute there, Jonathan.
Yep, you're on mute, I think, Jonathan.
I am indeed. Excuse me. Is there anything you'd like to contribute on this?
Can I just confirm what Alex just said, and that is that the expansion of jurisdiction to the other free zones is under active consideration. There are 26 other free zones. There are 26 free zones in Dubai, including the DIFC. So there's 25 others, and there would be potentially a lot of cases arising from that. So it does give rise to resourcing issues. So one of the things we're looking at, as Alexander mentioned, is what he called a hybrid model, whether we have a filter on the cases coming from there. So there might be a value filter. So that unless it's a case above a certain value, then we don't take it. But we're very keen to expand our jurisdiction to those areas for the same reason. We think the purpose of those areas is to promote international trade into those free zones. That's why we were created, to promote international trade into the DIFC. So we should provide the same benefit to those other free zones. The other point I'd just like to finish on, though, was that just to segue into relation both the banking guarantee issues and the conflict of interest issues, conflict of jurisdiction issues. One of the problems that's bedeviled a lot of the banking cases is this conflict of jurisdiction and the attempt to obtain a lengthy stay by commencing proceedings in the onshore courts. Commonly, a guarantor, when sued in the DIFC court, would commence proceedings in the onshore courts for a declaration that the guarantee is forged. And then under the old law would say, I'm entitled to an automatic stay. And the real problem was that under the old body, the old JJC took forever to make a decision. And so you get a stay for up to 18 months or 2 years. And then it got even worse because the JJC basically ceased to operate for about 2 years during the pandemic. So no decisions came out of it at all. Out of desperation, not out of desperation, we construed the decree so that there wasn't an automatic stay unless there was an actual conflict of interest. But the new tribunal, which is the Judicial Conflicts Tribunal, we think will resolve that problem. It's going to operate a lot quicker. And I can say that with confidence because the registrar of the DIFC court is the registrar of that tribunal. And so she has an interest in making sure that the cases go through that tribunal quickly. And if we can get them through that tribunal quickly, then the incentive for manufacturing jurisdictional disputes will dissipate. Because if you only get a stay for 2 months, it's not going to be worth your time and trouble. So I think that is promising. I think that conflict issue and the way it was resolved was a blight on the jurisdiction. It did create delays that were, I think, highly undesirable, but we hope we've solved that.
Well, look, thank you very much indeed. I'm really pleased we've been able to capture your thoughts on those 2 points at the end, Chief Justice. It's 9 o'clock, and we say we bring it home in time, and we hope we have. Thank you for staying with us, everybody. There has been no attrition during the webinar. That is very gratifying for all concerned. We do hope that you appreciate the opportunity to hear the thoughts and comments of the Chief Justice and our contributions on this 39 Essex Chambers webinar on DIFC banking and financial services disputes. We do look forward to spending time next week in Dubai during Dubai International Arbitration Week. And perhaps we will have the opportunity to meet some of you, if greeted there, and to socialise in the more conventional post-seminar manner during that time. Thank you again for staying with us.